Under Section 375 of Penal Code, rape is a crime where a man has sexual intercourse with a woman without her consent, or the consent was given by mistake, or the woman is under 16 years old who does not have the capacity to consent. Sexual intercourse was also explained to be the penetration of penis, and any slight penetration suffice. There were some reforms made to the Sexual Offences Law, such as the introduction of Sexual Offences Against Children Act 2017 and the amendment made to the Penal Code on rape law. However, such reforms are far less than what is needed, and there are still gaps in the law which is awaiting to be further reformed. In this video, we will be discussing the areas in rape law that needs to be reviewed and reformed.
Now, I'll be talking about marital rape. In Section 375 of the Penal Code, there is an exception to the law of rape where it expressly exempts the commission of rape by a husband to the wife. However, there are in fact about 1/3 of the domestic violence cases are sexual abuse within marriage according to the World Health Organization, and this is definitely an issue which required immediate attention. Previously, the immunity given to a husband for marital rape is based on the concept of property. That is, once a woman enters into marriage contract, she is said to be consented to sexual intercourse and is unable to retract that consent. However, this position has undergone a change in light of societal development and the recognition that humans, irrespective of gender, are entitled to equal human rights. In fact, the Malaysian government has committed itself to promoting the empowerment of women and the elimination of violence against women. This can be seen in the ratification and accession to the CEDAW and constitutional amendment to Article 8.2 of the Federal Constitution to prohibit discrimination based on gender. According to CEDAW, marital rape is a violation of women's basic human rights. Thus, by condoning marital rape, Malaysia is said to be not in compliance with the spirit of its international, regional, and constitutional commitment to protect women from violence and accord them human rights. The marital exemption in rape discriminates between married and unmarried women's rights and provides a married woman with a lower level of protection of law. This is said to be contrary to Article 8, where every woman is to be given equal protection of the law. It is also said to be contrary to Article 5, where women are entitled to the right to personal liberty to consent to sexual intercourse with a husband. Moreover, the impact of marital rape is actually even more severe than stranger rape. When you are raped by a stranger, you have to live with a frightening memory. But when you are raped by your husband, you have to live with your rapist. According to the rape report, rape within marriage causes great and continuous suffering of physical and psychological trauma to the victim and should be criminalized. Apart from that, the insertion of Section 375A, which punishes the husband who causes hurt or fear of death to his wife in order to have sexual intercourse with her, did not really solve the issue. The actor's risk for this offense is hurt and not the sexual intercourse itself. Apart from creating a special category of hurt with a greater punishment, this section does not appear to come anywhere near to criminalizing marital rape. Moreover, the penalty of this provision, which involves a maximum 5 years of imprisonment, is also too lenient compared to the non-marital rape punishment, which provides for a maximum jail term of 30 years. In the UK, the House of Lords case of R&R made clear that there will be no more marital exemption in rape under English law. It is stated that a rapist remains a rapist subject to the criminal law, irrespective of his relationship with his victim. The crucial element here is whether the sexual intercourse is consented to, and the fact that the wife had consented to it through marriage does not mean that it is irrevocable. The act of marital rape has been criminalized in more than 50 countries, including the United States, Singapore, and South Africa, as more countries recognize the harm marital rape causes to the victim. Thus, it is proposed that law in Malaysia should be the same too. Moreover, another detrimental issue regarding marital rape would be men charged with raping escape sentences by marrying the child victim. This is caused by the contradiction of the age statutory rape law and the age of law marriage. Malaysian civil law sets the minimum age of marriage at 18, but 16-year-old girls and older can marry with the permission of their state's chief minister. The matter is even worse under Islamic law, where girls under 16 can get married with permission of a Sharia court. Thus, it is very common for rapists to marry their victims, especially when they are underage, to cover up their crime. Thus, it is proposed that marital assumption in rape should be removed. In short, marriage should not be licensed to rape. Hence, it is proposed that the exception to Section 375 and 375A should be removed in light of the detrimental effect caused by marital rape as discussed just now.
In Malaysia, it is very clearly shown by Section 375 of the Penal Code that the offence of rape can only be committed by a man to a woman. The downside of having such a gender-specific law is that it will cause the other possible victims of rape to not able to seek help legally. This group of people will be generally discussed now. Do you know that about 1 in 33 American men have experienced an attempted or completed rape in their lifetime? And 1 out of 10 victims are male. Although there's no data readily available in Malaysia, it does not mean that it is not happening in our country. Instead, it kind of suggests that the issue of woman on man rape lack attention from the public in Malaysia. Gender stereotypes and social stigmas such as man is stronger than woman and it is always the man make it very difficult for men to receive proper justice. Malaysian Medical Association's president, Datuk Dr. Tamasilan, confirmed that much like female erectile response, the male erectile response is involuntary, which means that a man need not to be aroused for his penis to become erect and be placed into a woman's vagina. Hence, it is completely possible for an unwilling man to be made to engage in sexual activity. Similarly, little attention is paid to man rape man and woman rape woman cases. Malaysia is a multi-ethnic and multicultural country, hence policies and regulations have to be set in a way that it is compliant with religious values. However, individuals who are from the LGBTQI+ community are more susceptible to criminal offence, specifically Section 377A, which indirectly criminalizes gay sexual activities and regarded such act as against the order of nature. To cite an instance, some months ago, the Deputy Minister of the Prime Minister's Department proposed to provide a heavier punishment on the LGBTQI+ community, saying that the current sentence was not giving enough effect on this particular community. Besides, Section 375 fails to protect the victims of same-sex rape. For example, when a sexual activity is not consented by a gay man, they have the rights to be treated with equality and respect, just like any other heterosexual individuals. With that being said, any forms of discriminations towards this specific minority community are strictly not acceptable. Moreover, the law fails to cover rape involving people who undergo gender reassignment. In Malaysia, declaration under Specific Relief Act 1950 by the court has to be made to change one's gender. But what if the act happens before the declaration? Or how about the people who chose not to seek for declaration but continue living as the gender they desire? In the English case of Corbett and Corbett, the court held that male to female transsexual cannot legally be the victim of rape, and it is legally not possible to change the sex one is born with. It was further confirmed in the case of R. and Tans and others that the principle in Corbett applies not only in family law but also criminal context. However, New Zealand did not follow such an approach. The word genitalia in Section 128 subsection 2 and 5 of the Crimes Act 1961 includes an artificial vagina created by surgery on a biological male. We propose that Malaysia should not follow the English approach, and any person who has undergone gender reassignment should be regarded as the gender they choose to become, even when the declaration hasn't been made. And artificial sex organs should be made no difference as the original one that is born with. To sub-conclude, it is submitted that the law should be amended to protect the modesty and dignity of all humans, both females and males, including transsexuals, LGBTQ, and other possible minorities. The best way is to expand the legal definition of rape so that the gender of the victim becomes irrelevant, at the same time closing the transsexual or hermaphrodite loophole. Amending the section with any person, like how the UK and Thailand did, would definitely widen the scope of rape law. To avoid contradictions of law, sexual acts between two consenting adults should not be criminalized, whether it is homosexual or heterosexual individuals. Therefore, it should be removed from the sexual offences that are considered against the order of nature in the Penal Code, specifically Section 377A.
According to Section 375G of Penal Code, having sexual activity with a woman under 16 is statutory rape where the consent is irrelevant. This provision aims to protect the minors, but due to the development nowadays, there are some criticism that sparked up, calling for a reform of Penal Code to fit this new era. Firstly, the disputable issue is the age of consent to sex. Section 90, subsection C of Penal Code stated that a consent cannot be given by the person who is under 12 years old. However, this section seems to have contradicted Section 375G, as the consent of women under 16 is not relevant. Section 14 of SOACA 2017, which states that sexually assaulting a minor below 18 is illegal, have further contradicted the age of consent in Section 375G. Would this mean that the accused can have sex with a girl but is not allowed to touch her body? This leaves the court with a reasonable amount of confusion in this area, especially when the victim is between 16 to 18 years old. Therefore, the age of consent should be standardized. So, what is a standard and appropriate age to consent to sexual activity? With recent surveys, teenagers have more knowledge in sex education, rendering them to be sexually active much earlier than 16 years old. The age of consent varies in different countries due to the different situation and education level in the countries. The age of consent in Malaysia should be lowered to 15 years old, as teenagers would normally receive their sex education latest by 15 in their Form 3 science subject. The girl of 15-year-old and above would be sufficiently capable of understanding the act and consequences of sexual intercourse. Although a 1-year decrease in the age of consent may seem unnecessary, it can actually make a difference based on a survey conducted worldwide. Out of 174 underage consensual cases, 38 cases involve 15-year-olds. This would mean that if the minimum age of consent stands at 16, there will be 21% more men who will be held guilty for having consensual sex with a 15-year-old girl, even when she is fully capable of understanding the consequence of the act. Furthermore, there may be circumstances where couples are so in love with each other and willingly consented to sex. A consensual sex between couples should be distinguished with a rape that is an unwanted, illegal sexual intercourse without consent. Sex by teenagers are usually driven by heated brains and are not done with the intention to commit rape. With such, the clause in age exemption, also known as Romeo and Juliet laws in US, is significantly important with the purpose to decriminalize consensual sex between two individuals whose age gap is of 4 years or less. Such exemption should be implemented in Malaysia to prevent criminalizing the mere innocent act of the couple who are genuinely in love, provided that both parties consented to it. In summary, the Penal Code should be reformed as the current age of consent of 16 years old no longer fits the current society and should be lowered to 15. Besides, to clear the confusion caused by the contradiction in age ranges found in SOACA, Section 90 and Section 375, Section 90 should not be referred in statutory rape cases at all, and Section 14 of SOACA should also be removed so that the law is in line with Penal Code. The victim of physical sexual assault that was initially protected by Section 14 can still be protected by Section 354 and Section 509 of Penal Code. Also, the Romeo and Juliet law should also be implemented in Malaysia to be the exception to the criminalization of underage sex when the couples are of the age difference of 4 years or less. Moving on, amendments need to be made to Section 375 to further enhance this provision by including other elements into this section, as well as removing certain provisions that has unnecessarily overcomplicate the law of rape. It is found that Section 375 is not exhaustive in the modern context. The scope of rape ought to be extended, as the definition of rape must always be re-evaluated to accommodate society's needs. Firstly, is a need to include anal and oral sex. To prove that sexual intercourse has taken place under Section 375, the prosecution must prove that the accused penis penetrated with the victim's vagina. As such, Section 375 does not include non-penile penetration, be it anal, oral, or any other foreign objects, as it only considers intercourse to occur the moment when penile penetration takes place. In Bunyai Anak Jalong against private prosecutor, both perpetrators were acquitted because the prosecutor failed to prove penetration of vagina was done by the penis. In 2007, an 8-year-old girl was murdered and her cause of death was bacterial infection in her private parts caused by the penetration of brinjal and cucumber. So, it is important that Section 375 takes non-penile penetration into account. There are in fact provisions in the Penal Code that penalizes non-penile penetration and are specifically categorized as carnal intercourse against the cause of nature. Section 377A, which provides for anal and oral sex, and Section 377CA on penetration by objects and other body parts. The problem with this is that to charge a person for non-penile penetration offense, it needs to be specifically under these two provisions. If not, they will be acquitted because Section 375 does not provide for such an offense. In the UK, Sexual Offences Act 2003 definition of rape has been extended to cover the penetration of the vagina, anus, or mouth of the victim with the penis of the perpetrator. As seen in Regina against Ismail, Regina against H, oral sex was considered rape, and in Regina against B, the accused was convicted for committing anal rape. Australia and New Zealand is even more expensive for their rape offences, which covers the introduction of penis of a person into the anus or mouth of another person, as well as penile penetration of vagina or genitalia. India and Thailand have also broadened their meaning of rape. Non-penile penetration is recognized internationally as rape. In the prosecutor against Anto Frunzija, the trial chamber of International Criminal Tribunal for the former Yugoslavia explained that under international criminal law, the offense of rape comprises of vagina, anus, oral, and other foreign objects used by the perpetrator. Therefore, it is crucial that Malaysia amend Section 375 to widen its definition of sexual intercourse to protect victims of non-penile penetration and to ensure Malaysia is in line with international standards. Section 375 is also silent about the requirement of mens rea. Therefore, there's a need to include this element. The position in Malaysia when it comes to mental element is that the court will consider whether there was a mistake of fact in the minds of the accused person when they presume that the victim consented under Section 79. This is a defense which can be raised by the accused to allow him to be acquitted from the rape charge if he, by a reason of mistake of fact in good faith, believes that the victim was consenting to the act. In Teo Eng Chan, where the accused relied on Section 79 to be acquitted from their rape charges. As Section 79 is a defense, the burden of proof is on the accused to prove the element of mistake of fact. Thus, if the element of mens rea is stated in Section 375, the burden of proving will lie on the prosecution. So, it is proposed that mental element of rape needs to be clearly outlined in Section 375 and not to be referred to as a separate provision. Malaysia may follow the English Sexual Offences Act 2003, which states that the accused must not have a reasonable belief that the victim consented to the sexual act. To conclude, one of the most important general principles of criminal law is that a person should not be convicted of a serious criminal offense unless he or she intended to do the forbidden act or was aware of the circumstances which made the act criminal. So, by following the UK and having mens rea in our provision, it will set a clear guideline for the mental element required to hold a person liable for rape.
Section 375 of the Penal Code does not only provide the definition of rape, but also the 7 circumstances of making sexual intercourse rape. Similar law can be found in other jurisdictions, however, in a simpler form, without stating several circumstances. For example, in Singapore and the UK, the law simply provides that rape only occurs when there is no consent given to the penetration. It is suggested that the Malaysian law regarding the circumstances making sexual intercourse rape can be simplified by removing subsection A, C, and D. Firstly, subsection A should be removed because if a victim is not willing to have sexual intercourse, it should be deemed as she is not consenting to it. Such circumstance is then covered under subsection B. Moving on to subsection C and D, where there was consent. These two can also be removed because they have already been covered under section 90, which concerns the issue of consent. Section 90A states that consent given out of fear or misconception of fact is not a valid consent. As for subsection E, although it is similar to section 90B, it is actually wider than it because it is not confined to only unsoundness of mind or intoxication. Therefore, subsection E should be retained. Hence, subsections A, C, and D of section 375 can be removed to simplify the law and prevent any unnecessary confusion without causing any lacuna. We will now be discussing about the punishment for rape. Section 376, subsection 1 provides that the sexual offenders for rape are sentenced to imprisonment not more than 20 years and liable to whipping. Is this a harsh sentence? In certain countries, for example in the UK and India, such offense is punishable by life sentences. Besides, death penalty is a must in China, Iran, and Egypt. As compared to other countries, the maximum punishment for rape in Malaysia is apparently far more lighter. Even for the offenses of gang rape or aggravated rape, the maximum sentence is only 30 years. In fact, the victim of rape can suffer both physical and psychological trauma, which can be long-lasting. It is proposed that the maximum punishment for all the rape offenses in the penal code should be extended to imprisonment for life. Strong sentencing for the crime of rape will send a strong message in the society. The courts can then award punishments proportionate to the gravity of the crime, depending on the extent of the brutality of the rapist and the damage caused to the victim. Imprisonment for life can be necessary when the court finds the accused as a real threat to the public. It is noteworthy that there is no specific provision in our penal code to punish repeated rape offenders. Although Section 75 does provide that repeat offenders of certain offenses can be given double the punishment, the offense of rape is not covered under that section. According to Indian Penal Code, Section 376E provides that a repeated rape offender will have to be imprisoned for the rest of his life or sentenced to death. The repeated rape offenders who have failed to learn from their lessons from the initial punishments deserve to be punished more severely than first-time offenders. Therefore, there is a need to include a specific provision in our penal code to punish repeated rape offenders. It is suggested that they shall be punished for imprisonment for life to serve as a deterrent to others. In conclusion, our proposals are, firstly, to remove the exceptions of Section 375 and Section 375A. Secondly, Section 375, which is gender-specific, should be amended by replacing it with phrase "any person" to protect every individual. Thirdly, to decrease the minor's age of consent for sex to 15 years old and incorporate the Romeo and Juliet law. Fourth, Section 375 needs to be enhanced by including non-penile penetration and mens rea. Fifth, subsections A, C, and D of Section 375 can be removed, and also to extend the maximum sentences for all the rape offenses to imprisonment for life. And the last one is to include a specific provision for the repeated rape offenders to be punished for imprisonment for life. The current rape law in Malaysia should be improved and broadened to prevent and minimize the rape crimes. This would ensure that justice is served to the potential victims and also the innocent accused. Moreover, to make sure that the perpetrators will be held accountable for their actions. We hope that our proposals are able to address the current loopholes and flaws of the rape law in our country.